everyone. Thank you so much for coming on a Monday evening. I know it's quite an achievement. I'm very grateful for having the room full. I'm Rita Sven. I'm assistant professor of law here at the LSE Law School. I'm specialized in environmental law and climate justice. And it's my great pleasure to welcome you all tonight for this event on toxic legacies, holding multinational giants accountable for historical pollution. In 1 week from now, the South African Supreme Court of Appeal in Johannesburg will be determining whether the appeal brought on behalf of women and children of the community of Kabwe, a class action case against AngloAmerican, one of mining giants that is headquartered here in London, is allowed to proceed. And today we've gathered a fantastic panel of experts to discuss this case, which could set really a landmark precedent for holding multinational corporations accountable for enduring lead pollution due to historical mining activities taking place in Zambia, including also during the British protectorate at that time in Zambia, known as Northern Rhodesia, that took place there from the 1920s up until the independence of Zambia in 1964. So this is really what we are interested in discussing this enduring notion of the toxic pollution, the legacies that we are trying to address tonight. So to discuss this issue tonight, we are joined by Zainab Rahim, who is Media and Communication Manager at Rights and Accountability in Development, a UK-based NGO that exposes and documents corporate wrongdoings, especially in the field of human rights and environmental protection. Zainab's introduction will be followed by Katarina Thiel here at the end, who is Senior Associate Solicitor at the International and Group Litigation Department at NIDE, where she's working with Richard Mirren and a team of South African-based attorneys on the Kabwe class action. Followed by Walker Tiachalinga, who is also an Associate Solicitor at NIDE's International and Group Claims Department, and who grew up in Kabwe. And the panel will end with Ashfaq Kaplan, who is Director of the Sustainability Regulation Observatory here at the LSE Global School of Sustainability, as well as Senior Fellow at AngloAmerican and former Director of the Law and Policy Program at Amnesty International. And just before passing the floor to our speakers, I wanted to thank indeed the co-organizers of the event tonight, so the LSE Global School of Sustainability, as well as the NGOs Action for Southern Africa and Rights and Accountability in Development. And I have to say that this impressive team that is with us tonight and facilitating the live stream has been set up by the Action for Southern Africa, and Julia, thank you for enabling this. Okay, so let's start with you, Zainab, who will offer us a short history of the Kabwe landmine and its related historical pollution. Great, fantastic. You want to? Yeah, sure. And it's on as well. You amplify the voice.
Thank you so much to all of you for coming today. Thank you, Rory, for coordinating this. So I'll start by saying Kabwe is an example, a really great example of an ecological disaster that unfolds generation after generation. Lead pollution is quite invisibilized, so it's not like the glooping oil spills that you have in the Shell Niger Delta case, or even the Kabwe River Zambia case that was earlier this year, which where millions of tons of waste was leached into the local waterways through another copper company. So the lead pollution can be quite hidden. It's also a great example of how a corporation can run under colonial rule. In this case, AngloAmerican had really strong ties to apartheid South Africa, and it thrived under it. And then after the independence of Zambia, that neo-colonial exploitation continued. It's also an example of how a company can leave without any cleanup or remediation, knowing full well the health consequences on the local population. And Kabwe a UN designated sacrifice zone, so it's also an example of how racialized communities are considered disposable, dispensable for the sake of profit. So just to give you a bit of background on Kabwe itself, so it's on the border region between northern Zambia and the copper belt of the DRC in the south. The discovery of rich deposits of lead and zinc in the early 1900s led to the Kabwe lead mine being built. It was called Broken Hill before. And communities were restructured around it. And the mine's owners developed the townships that are around the Kabwe mine. So racialized people were put into the most undesirable areas. You had black residents placed to the west of the mine, downwind of the mine dumps and the smelter. And you had the lead mine was operated by AngloAmerican, so I'll say the legal bit. So AngloAmerican allegedly had a key role in controlling, managing, supervising and advising on technical, medical and safety aspects of the operation of the mine. So they were the longest kind of operator. They were in the kind of region for 50 years before it was handed over to a state-owned company for about 20 years, and then it closed in 1994. And there's a really interesting bit in the report as well about tree ring analysis, where scientists have looked at the majority of the lead pollution and been able to trace it back through the time that AngloAmerican was in operation. So how the pollution was caused, it was caused through the extracting of the ore, the processing, the smelting process. Smelting fumes send lead dust over surrounding soil. And then you've got wind-blown dust, seasonal floods, and then in Zambia you have 9 months of dry season, so a lot of dust is thrown up into the air. And I'll briefly touch on how women and children are particularly affected by lead poisoning, but there is going to be a video that you'll see which goes into a little bit more. Lead poisoning affects babies and children in particular at the development stage. It affects their brains and central nervous system, and that's why it's an intergenerational problem. Children absorb it 5 times more than adults, and the peak seems to be toddlers age 2 because they tend to play in the soil or they put their hands to their mouth, etc. At low levels, lead poisoning causes learning difficulties, behavioural problems, and stunted growth. At high levels, you can have damage to the liver, nerve, stomach, and convulsions, and even fatalities. And in women, lead is transmitted through the placenta, through the breast milk, so there's risks of preeclampsia and miscarriage. And in areas where there's undernourishment, it also means there's a higher absorption of lead. So far, there hasn't been a sufficient cleanup process. There has been some projects associated with measuring blood lead levels, which are again mentioned in the report. But this is why this class action, and we're going to hear from the lawyers, is particularly interesting in terms of avenue for remediation and cleanup. What I will say as well is that the UN right to a clean, healthy and sustainable environment was only established 2 years ago, in 2022. There's not a single definition, but it's generally understood to encompass that human life should be in non-toxic conditions. It's not just symbolic, and it's not a privilege. This is now enshrined as a right. So it might be able to offer new tools to hold governments and corporations to account for environmental degradation. It might help to bolster some legal arguments and increase political pressure. And I think as we kind of enter this era where coal mines might shut down, some fossil fuel operations might shut down, it will be really interesting to see how the Kabwe case plays out. I think it's a really critical test and a warning. And it's not just fossil fuel operations. I will say I've got our report up here from last year. We've been looking at the green energy transition, in particular in the DRC in a town called Kabwe, where some of the biggest copper cobalt mines are. And we analysed water pollution last year, and we found some really devastating consequences on the health of the local population, especially in terms of women's health, but also in terms of agriculture and livelihoods. And we're now looking at air pollution. So that will be, we've started to monitor the air quality in Kabwe, and that will be kind of an investigation that we'll publish next year. So that's why we're going to be watching Kabwe closely, and I think it definitely presents a test and a warning for what's to come. Thank you.
Thank you. There's still some teachers here if you would like to.
Yeah, thank you very much, and it's good to see so many people at another evening, as Marie said. So I'll start just very briefly, and they have already set out the background, but just to repeat that the former Kabwe mine was one of Africa's most significant sites for lead and zinc mining. It operated from 1906 to 1994, and between 1925 and 1974 it was within the AngloAmerican group. So that's the period the case is concerned with. And at that period, the AngloAmerican South Africa was the head office of the Anglo group, and AngloAmerican South Africa is also the defendant in this case. So the class action proceedings were filed were commenced in October 2020 with the filing of a certification application in the Johannesburg High Court. This application was filed by 12 representative claimants who were represented by Multinational attorneys, which is a law firm based in Johannesburg, and Legacies are providing assistance. The claim alleges that, and again, David mentioned this briefly, that that from 1925 to 1974, Anglo played a key role in controlling, managing, supervising, and advising on the technical, medical, and safety aspects of the mine's operations. And it is alleged that Anglo failed to take steps to prevent the lead poisoning, and also failed to clean up the contaminated land, and that this failure then resulted in decades of environmental harm and health impacts on the local community. The claim was brought by the representative claimants on behalf of two classes. One is the classes of children under 18 who suffered injury from the lead exposure, and the other one is the class of women of childbearing age. And that is to do with the health risks that they face during pregnancy, to themselves, but also to their unborn children, which again, they have explained this. So, and yeah, I should say that based on statisticians' estimations, these two classes comprise about 140,000 people. I just thought I'd briefly go into why the case was brought in South Africa. The reason is because it was possible to bring an opt-out class action there, which is basically the only way this case can be brought, or can be brought in a way that is financially viable, where there's so many people and a claim of this nature. And because there is the availability of lawyers with experience in doing this type of claim, so we sent Molede and Legacies, and there's also third-party litigation funding that's available to the claimant, which assists in paying the extraordinary expenses that a claim of this type entails. So with that, I'll show a video with further background to the case. The sound might be.
Over 230,000 people live. Over 230,000 people live in the lead-contaminated town of Kabwe, Zambia. This was home to the world's largest lead mine for 80 years and was part of the AngloAmerican mining company group from 1925 till 1974.
There were serious deficiencies in control of lead emissions, which resulted in widespread contamination of the environment. the public health disaster that has entailed the poisoning of generations of children in the local communities was entirely predictable.
When they left, as a result of their operations, they have left an environmental disaster. When you look at the Clark study in the 1970s and the blood lead levels then and to the blood levels now, nothing has changed. So the very same lead poisoning that was happening at that time is continuing happening now. Studies have shown that the soil in the townships surrounding the mine has concentrations of lead more than 150 times higher than the relevant international standard of 400 milligrams per kilogram. Children are most at risk of lead poisoning because their brains and bodies are still developing.
The younger you are, the greater the risk. When a child is exposed in those early years, they can live their whole lives long with damaged hearts, damaged kidneys, and with impacts on the brain. And that cognitive loss is often permanent.
Lead in the blood is absorbed into the bones. During pregnancy, this lead is released. It crosses the placenta, causing harm to the unborn child. This is a serious risk for all girls and women of childbearing age in Kabwe. There is no safe level of lead in the body. Mental impairment can occur at levels as low as 5 micrograms per deciliter. Treatment is required at 45 micrograms per deciliter. Levels in excess of 100 micrograms per deciliter can be fatal. Various studies have shown that in some areas of Kabwe, all children under 7 have been found to have levels above 5 micrograms per deciliter. Around 50% have levels greater than 45 micrograms per deciliter, and many have levels above 100 micrograms per deciliter.
At those levels, you could expect to see convulsions, coma, permanent muscular paralysis, and that child could die.
Anglo today subscribes to human rights principles. Unfortunately, Anglo's practices at Kabwe seem totally at odds with its public commitments.
So what Anglos say about the case is that its conduct should be judged by the standards of the day rather than today's standards. We, on that point to the following. In 1969, Dr. Ian Lawrence, a young mine doctor, arrived in Kabwe and shortly after that noticed that local children were dying. So he set out to test 500 children for lead. And what he found was that virtually all of their blood lead levels were above 40 micrograms per deciliter, and many exceeded 100 micrograms per deciliter. And even by the lowest standards at that time, these blood lead levels were excessive. So this then led to a report being commissioned in 1970 from two eminent industrial health experts, Professor Lane and Dr. King from Manchester University. And they recommended, amongst other things, that the topsoil should be replaced in the township, and that residents in the township closest to the mine should be moved. However, the mine general manager at the time rebuffed this proposal and said, saying that it would be far too expensive and that it would cause too much alarm. So in the end, around 3,000 of the workers were relocated. However, 8,000 were left behind, and none of the residents that weren't workers at the mine were relocated. Then in 1972, a brief letter appeared in the British Medical Journal, in which Dr. Nickling, another mine doctor, noticed his alarm at the death of 5 children living close to the mine in Kabwe due to lead poisoning. And then finally, from 1971 to 1974, another doctor at the mine, Dr. Len Clark, surveyed environmental lead in Kabwe and blood lead levels in children. And then in 1975 published a thesis which was based on this research, and he found that the primary source of environmental lead pollution was the mine, and that this was correlated with dangerously high blood lead levels. Despite all this, Anglo says that Legacies, which took over the mine in 1974, which was already mentioned, and the predecessors, which operated the mine before Anglo was involved in the 1925, are to blame entirely. So the claimant's response to that is, in addition to the evidence that I just ran through briefly, regarding the Anglo's awareness of the risks of lead poisoning at the time, the claimants say that according to our experts, the highest levels of lead production were during the period of Anglo's involvement, and on this basis that a corresponding proportion of the lead in the environment of the Kabwe district today was caused during this time. And in addition, our experts have identified major deficiencies in emission control before 1974, so prior to ZCCM's involvement. The other point that I just briefly wanted to respond to is that Anglo say that they were only a minor investor and didn't own the mine. So that's accepted. They didn't own the mine, but it misses the point legally. Liability of the parent company has been set up very clearly by the UK Supreme Court in a case called Lungobe and Vedanta. And it's not about the shareholding, it's about the nature of the parent company's involvement in vis-a-vis the nature of the harm. So what is alleged here is that they had control over the relevant function and that the nature of the functions carried out by them and the deficiencies and the failure to remediate caused the harm. So finally, the judgment and the appeal was coming up. So the certification application was heard in January 2023, and then a judgment was handed down in December 2023, in which the court dismissed the claimant's application. The central basis of the dismissal was that the case is factually hopeless and the legal arguments untenable. In other words, that the claimants don't have an arguable case. We'll hear these arguments be ventilated in court next week, but just very briefly I wanted to go through some of the claimant's arguments in overview. And these are the, so to say, more the overarching points. So the claimants say that the conclusion was reached on the basis that the court assessed the evidence in the same manner that a trial court would. So that means at a preliminary stage, or the certification stage, without the benefit of discovery, pre-trial processes, or oral evidence, for example, from the experts, and there are very many expert reports, and the claimants say that's something that the claimant should be entitled to, in particular where many issues are heavily contested. The court also concluded that the claimant's case isn't going to get any better, so that there won't be any disclosure that from Anglo that would improve the case, and we've said that we've put up evidence to the contrary. In addition, despite the evidence that we talked about earlier, the judgment held that Anglo had no knowledge of poisoning until 1975. And then the final point I wanted to make is that the compliance, that the court had that compliance with industry standards of the time gets Anglo off the hook. However, what the claimants say is that Anglo didn't actually adhere to its own experts' advice, but also that the test of negligence isn't actually about the prevailing standards, but that it's an objective standard, it's the requisite standard, and so showing that others were just as negligent doesn't assist in that case. I think I'll stop here, probably reached my time limits, but yeah, I have to take my questions later.
Thanks very much, Victoria. So we've heard about the history of Kabwe from Zainab, and from Katerina we've heard about the legal side. So whilst I'm a lawyer, I will be focusing on the non-lawyer bits, which is my experience of growing up in Kabwe, where I lived until the mine was privatized. That was in about 95, when my family moved to another part of Zambia. But before I do that, I'd just like to draw attention to the report itself, which is not a declaration in front of me, and also specifically to Action for Southern Africa and Environment Africa. So the two charities that worked hard to put the report together. Within the report, you'll also see some other names, such as RAID, the organization that Zainab works for, the London Mining Network, who've put that together. And importantly, there are, I think, 4 testaments from mums and children who live in Kabwe and are affected by these issues. So please do take time to read that. I will comment on 3 main things from my experience, and those are sort of touched upon in the report. So the first is the childhood experience. And then when you read the report, you'll also see that they comment on sort of some of the medical interventions. And then lastly, there are comments on the environment of Kabwe and how that sort of impacts on people's experience of living there. So on the cover of the report, you will see a child playing with soil. And that's a very common experience of any children, really. It's not a Zambia or Kabwe thing. You will see the children here encouraged to play with Play-Doh, Macy play, some people might call it, also called Macy kitchens or something like that. Children of that age are encouraged to, that is good for their development. And that's not different for children in Zambia. It wasn't different for my experience growing up in Kabwe, how we play with soil, we sort of make figurines and so on. So the catch-22 that most parents and households in these regions face is that on the one hand they have to encourage their children to do these things, to play with soil, to interact with the environment, but also to cope with the risks of doing that when you live in a town where the soil is contaminated. So I've spoken about how I play with soil, but in my household or in my sort of yard where our house was, we also grew crops. Some of those crops grew in the ground. We're talking about crops like carrots, for instance, onions, groundnuts, things that you'd expect to sort of grow in the ground. And most families in Zambia live subsist by, in part, growing these healthy vegetables in their gardens. But again, the catch-22 that most people find themselves is that on the one hand, they need to enjoy this fruit, but on the other, this, as you will learn from the report, is impacted by lead poisoning because part of the way that lead moves up from the ground is through the crops that we grow. So, what do families do? How do they sort of supplement their income? How do they supplement their diet by growing these things? So again, it's that sort of juggling act of doing these things, but also being aware of the risks and of lead poisoning. In my community, we also have sort of football pitches where different sort of sub-communities within there we play football. There'll be some team rivalries, etc. But all of that is, for the most part, played on pitches which don't have grass in them. So you just basically often be playing barefoot on open ground. That in itself is risky, but what do you do in response? Do you tell people to never play football again because of the risk of lead poisoning, or do you just put in place measures to mitigate that risk? So people end up inheriting this almost, I think Zainab, you referred to an invisible kind of like danger, which everyone is aware there is this thing that is around you, but you never quite know how to effectively deal with it. I think in Kabwe they call it Ichitofu, which is like the local name for lead or the soil that has lead in it. And people were, I guess, just walking with an awareness that this is present and this is there. My parents were both health practitioners. Mom was a midwife, and so she was at the forefront of seeing a lot of children, particularly under 5, presenting with symptoms of lead poisoning. So in the most extreme cases, this might be seizures or convulsions, where a child is convulsing, and then in those cases they would know that the child is quite far ahead, and they would have to put them on the IV drip or something to that effect to help. On the other end of the spectrum, there was really uncertainty as to whether a child is sick because of lead poisoning or other causes, like malaria, for instance, or in these communities might be malnutrition, so poor diet caused by other things. But there was always this, again, sort of like delicate balance of is it lead poisoning if the symptoms are not extreme? Do we need to intervene? And it wasn't just the nurses and health practitioners who were unsure, it was parents as well. So parents would keep their children, for instance, from going to clinic because they might think, the headache will subsist or the temperature will go down, or it might be malaria, so they administer sort of anti-malaria drugs, not knowing that it might be something serious. So mom says these are some of the things that people would present with. my father was more on the kind of, so he was a GP and he would see more people who have been underground. So if there is an accident underground caused by blasting operations, because the way you mine for these minerals is if you set up dynamite underground, you blast it, a lot of dust in the air. Good practice would be that you water down the soil in order that there is less dust, but that wasn't always possible. So people would present again with breathing difficulties, in extreme cases would be with bleeding, so they would have to administer medication to them. So those were sort of like the realities that we grew up with, or I grew up with, an awareness of the danger, but also an awareness that also dangerous was, I guess, to keep your children indoors, so children had to grow and interact with the environment, but you had to kind of balance the risks of lead poisoning with normal childhood. And then the third point that I wanted to highlight is how the legacy of mining in places like Kabwe and a lot of mining communities in Zambia is that despite it having taken place a long time ago, it leaves quite a permanent mark, both on the environment, but also on how people live. So in the report we will read about a canal, for instance, that runs parallel to Kabwe, to Choa Township where I grew up, and that stream is often dredged to make sure that the effluent from the mine can flow through it. And that shapes how people interact with their community. I remember when we were young, we sort of go sliding down those sort of heaps of soil that have been dredged from the canal during the rainy season. But that in itself is, a source of fun, but also a source of danger. So again, it's that interaction. And then you will also read about in the report what are called black mountains. So these are slag heaps of mining effluents or mining material that is left over. In modern times, that is also being remined to extract more lead. But all of those are almost like permanent features of the community, and communities have to either walk around, drive around, or interact with it. So despite, for instance, Anglo having left in 1974, the features and the evidence of what they left behind is there, and a lot of these almost become like semi-permanent marks of the environment which people have to contend with, whether it's a canal that moves mining effluent, or mountains, as they're called, so high hills which are left over, which people have to interact with, or dust being blown in the direction of where communities were built, and people again have to contend with this so many years. So I think that the nature of mining itself is that it's not the sort of thing that you, unless you bury perhaps things underground, it's not the sort of thing that you can do and then just leave. It does leave a sort of permanent change that you can see physically, but also that people have to then sort of, walk around, both from a health perspective, but also generally their experience. So then those are my contributions.
Hello everyone. I was telling my colleagues that their presentations will be the most interesting part of the presentations. Mine is going to be the most boring part of the presentation, so I encourage you to, sit up and you're going to have to concentrate to pay attention to this. So yeah, you give me one. So I'm approaching this from the hyper-legal perspective in terms of what are the legal obligations of any country in dealing with multinational multinational accountability. Obviously, each country has different national laws, but in terms of what international law requires, let's go over that. So I'm going to start with. Should I control the out? Yeah. So the guiding, you may be familiar with the UN Guiding Principles on Business and Human Rights. So this came out of a process led by a UN Special Representative on Business and Human Rights, who developed a whole set of principles on business and human rights. A lot of this was done in cooperation with businesses, which is why you see some many multinationals, including AngloAmerican, saying that, oh yeah, we abide by the UN Guiding Principles on Business and Human Rights. And they were endorsed by the UN Human Rights Council in 2011. So it gives us a higher level of status in terms of guidance. So what we're going to talk about is some of these standards and what how any court in a country should be abiding by them in dealing with the obligations of multinationals. So the guiding principles state that states should ensure through whatever means, judicial, legal, administrative, that when human rights abuses occur within their territory or jurisdiction, that those affected have access to effective remedy. There was a long debate, and to some extent there's a huge debate on what jurisdiction means, right? But jurisdiction is not the same as territory. And the best answer that I believe in, and many others have argued, is that jurisdiction is where a state has effective control over the rights of an individual. Then we're going to the UN Committee on Economic and Social Rights, Economic, Social, and Cultural Rights. This is very important because 170-ish countries are party to that treaty, including obviously the UK, including South Africa, ratified it in 2015. And it's one of the most ignored treaties, but actually has a huge content, right? It deals with things like the right to water, the right to health, importantly, which is key in this context. So most human rights, most United Nations treaty bodies, i.e. the bodies which are elected by states to interpret human rights treaties, have accepted that states have jurisdiction over all situations where they have control of the rights of individuals. That same approach has been taken by the Inter-American system, by the Multinational Court of Justice, by the African Court of Human Rights, People's Rights, and the Commission. The big outstanding exception is the European Court of Human Rights, which is actually very, very conservative in this domain. Tell that to your Reform Party friends if you have any next time. And next time they dump on the European Court, it's actually one of the most conservative regional courts in the entire world. But be that as it may, that wasn't the big issue in this case, and in a growing number of jurisdictions. But the important point here is it says that the obligation to protect, states have this obligation to protect, to ensure that business activities where they exercise control, that they ensure remedies for people who are affected. And this applies where, in a whole range of situations, such as where the business in question is registered in the territory. That's the main one that's relevant here. So this is I've pointed to one general comment, which interprets one set of issues, but the same, you'll see the same in many of their other general comments on substantive rights, health, food, and the others. The same approach has been taken by treaty bodies such as the UN Committee on the Rights of the Child, importantly, for this case, and the UN Committee on Racial Discrimination and others. I think Katerina referred already to the British Supreme Court case, which accepts this principle of holding businesses to account when they are the parent company of a subsidiary that causes harm abroad. So that's in the Supreme Court in the UK, also in the Netherlands. There is similar jurisprudence. We're obviously hoping that South Africa would continue this trend. And in this case, it doesn't seem that jurisdiction was a big concern. And that's actually one of the most disheartening things. I mean, you think you've won, the law has moved, and so people can hold corporations to account, but then you find that, and it's one of the situations, the devil's in the details, that on a whole range of approaches, courts can sometimes be very, very restrictive when applying the law to particular individuals. So when you go back to the standards and how they point to not just the principle of holding corporations, but also dealing with really the practical barriers that get in the way of holding remedy, ensuring remedy. So that's that position was set out by the guiding principle. They gave a few examples. Things like situations where, as Katerina mentioned, the fee structure in a particular country doesn't allow for remedy, or there are restrictive options that class actions are permitted in particular contexts, and that those prevent effective remedies. Some of these very detailed things really make a difference. So that's in the commentary to Principle 26. The Committee on Economic and Social Rights has also set out some of these barriers. So some of them that they point to is things such as admissibility. What sort of evidence is admissible and can be presented? Ensuring that there's access to information. In some cases, people can't secure a remedy because they just don't have access to the information. In many cases, and I think that's relevant to this case, that information sits in the archives or records of the multinational at hand. Particularly if the question is, what do you know, when did you know it? Well, their records would provide that information. So that's why in many cases the issues such as the burden of proof is very important, and the remedies, the procedures need to make sure that the burden of proof isn't unfairly put on the victims. So I'll stop there. There's also some guidance from various experts, such as there's a UN expert on toxic waste who has provided, who's developed good practices on ensuring accountability for toxic waste that gets into some of these issues. So yeah, that was pretty boring, but these are the very important standards, and they make a huge difference as to whether people can actually secure a remedy before the courts.
Thank you so much.
Thank you so much, everyone. I think maybe it's also important now it's supposed to work. Okay, so we have to speak a bit closer to the mic. So that leaves us with a good 45 minutes for Q&A. Before passing the